Hey everybody, thank you very much for joining. I can see there are plenty of people signed up for this excellent webinar. This webinar is hosted by Your Overseas Home, helping people buy a ski property in France and what every buyer should ask a notaire. I am absolutely delighted, and everyone there should be very privileged. We are joined today by Simon Attey from Alpine 3V Notaires. He is a specialist in helping buyers of ski property and is fortunate enough to have his office in Meribel, where we are all trying to get to go. Just a little bit about my background. My name is Mark Lightfoot. I am the owner and founder of SnowOnly. SnowOnly.com is where you'll find around 9,000 ski chalets in 17 countries in something around 280 ski resorts. We are a property portal dedicated to buying and selling of ski properties. I've been in real estate for the best part of 25 years, showing my age a little bit, but sadly I have been all over the world, in Asia, Europe, and SnowOnly was born around 8 years ago, and we've managed to make many contacts within the industry, Simon Attey being one of our very privileged contacts. So today we'll be discussing what every buyer should ask a notaire. We've got around 45 minutes or so. So there is a chat on the side of your screen. So please feel free to ask any questions as we will go. I think this will probably solicit a lot of questions from people that are listening. So we have questions, please feel free to answer. We'll try to get through as many as possible once we have asked the questions that we've already arranged, and maybe that will cover quite a lot anyway. Please feel free afterwards to get in contact with Simon. We will pass the details afterwards, and you can contact Simon yourself with any questions if you are considering buying a ski property in France. So I guess the first question is, Simon, a little bit over to you. Can you give us a little bit of background about yourself, just so we can set a tone for the webinar?
Sure. Hi, Mark. Hi, everyone. Yeah, my background is that I was born and bred in the UK, studied law and became a solicitor in the UK. And after 15 years or so, decided to move to France with my wife, who's French, and requalified over here as a notaire. That was back in 2008. And since then, I've been working in the Alps, but, assisting clients throughout France with primarily property-related transactions, whether it's purchases or sales, or in the context of successions or gifts and that kind of thing, and also, various other things that the notaires do in France. And I work often with English-speaking clients, whether from the UK or elsewhere overseas, just to help them overcome the language barriers and the sort of difficulties and the differences between the systems that they're used to in the French legal system.
And you don't, just so we can cover this, there's all ski resorts. It's not anything specific. There's no, everything can come to you, even though you're based in Meribel, of course.
Oh, absolutely. Yeah, I mean, we deal with property transactions throughout France. So, I mean, it's not necessarily, it's not even limited to sort of ski properties necessarily, yeah. But in reality, we tend to, the bulk of the transactions that we're involved in are in ski resorts, in either in Savoie or in Haute-Savoie, which is, where the most of the ski resorts are situated in France anyway.
Yeah. Okay, as we have limited time, Simon, we'll get into the hard questions that I'm sure all the people that are listening would like the answers from. So first of all, what is the role of a notaire in France?
Well, I'll start maybe by just saying there seems to be a common misconception in the UK that a notaire is a kind of a government-appointed rubber stamper, but doesn't really do much more than that, which is which is far from the truth. I mean, effectively, in the context of a property transaction, then we have a role which is akin to that of a conveyancing solicitor, and so we deal with advising clients from the start to the end of the transaction, and ensure that they end up, well, if it's a buyer, then they end up having good legal title to the property they're purchasing, and that they're fully informed of the kind of risks and any information that they needs to be drawn to their attention in relation to the property they're purchasing. And on the seller's side, then effectively we're doing the same thing, but ensuring that they sell the property, that they're advised on the capital gains tax implications, and help them repatriating the funds. And then more generally, notaires, whilst there's a lot of our activity involves property transactions, purchases and sales, we do also, as a sort of core of our activity, get involved in advice on estate planning, dealing with successions when they happen, advising people on gifts of properties, making wills, and also on other transactions which are sort of property linked, like sales of businesses, hotels, restaurants, that kind of thing.
Yeah, understood. Just while you're on that, I just had a quick question. Who do you can represent them both, or buyer and seller? Or buyer or seller, sorry.
Yeah, we can. I mean, that's one of the main differences between the UK system, where a solicitor can only represent one party to a transaction. In France, a notaire can act for both parties. We have a general obligation to be impartial when dealing with a transaction, whether we're acting for one party or both. So we're not there to try and get the edge over one client in favour of another. Even if we're acting for only the seller or only the purchaser, we have a duty to ensure that the contract's balanced. And so I'd say probably traditionally probably about 50% of the transactions we're acting for both parties. Over the last few years, that's reduced slightly, but these days I'd say sort of 30 to 40%.
Yeah. Okay. So I guess then that leads on to this is always quite an interesting one, because we speak to a lot of our buyers and they say they're not ready to speak to a notaire in terms of how far they are down the property, whether it's initial contact through SnowOnly or whatever it is. So when do you say is the right time to engage your services, and should this be done even before they've made the offer on the property, etc.?
I mean, personally, I welcome a contact as early as possible in the process, because it can be helpful for clients to understand the process before they kind of launch into it, and to have some of the their initial questions answered, to make them in a better position to actually frame an offer and to work out how they might want to structure a transaction. But we're not always approached at the earliest stage of the transaction. It's quite often the case that it's only once an offer's been made and has been accepted that a client then starts looking for a notaire, and it's certainly preferable at the latest to get us involved at that stage, because in the property purchase process, the next stage is going to be the signature of a pre-sale agreement. Depending on whether it's an off-plan purchase or the purchase of an existing property, then the name and the nature of the agreement is slightly different. But at the end of the day, it's the agreement that's going to set out all of the terms and conditions, which are then going to be reproduced in the final purchase agreement. And so it's important to get us involved so that we can, give advice on the drafting of that initial agreement, and try and help doing the due diligence at that stage of the process, rather than finding yourselves locked in to something without fully understanding it and without having all the right questions asked at the earliest stage.
That would you just to reiterate, you'd say that was the most important one. That first agreement is almost the important one that sets the standard throughout the buying process.
Absolutely, because that's the document that sets out the terms and conditions of the future sale at the end of the day.
Yeah, understood. So in terms of if they manage to get you at the right time, let's hope that's the case, and you're in contact and the guys moving forward. Obviously, everyone on this call is going to want, what is the legal process of buying a, let's say, ski property, because that is what we're here for, but a ski property in France. What is the legal process?
So the system is slightly different depending on whether it's a purchase of an existing property or whether it's an off-plan purchase. If it's an existing property, then it's a two-stage process. The first stage is the signature of a document, which, I'll call it a preliminary sale contract because it has various names depending on who's drawn it up. But the French terms would either be compromis de vente or promesse de vente. And that document as I said earlier, it records the principle of the agreement to buy and sell, sets out the future conditions of the sale, and sets out the preconditions for completion which need to be fulfilled either on the seller's side or on the purchaser's side, which, for example, could be obtaining a loan. Once that agreement's been entered into, there's a 10-day cooling off period which will start running from when the purchaser is notified of a copy of the agreement, during which the purchaser could exercise a right to withdraw from the purchase. And if they don't, there's a deposit payable. Generally speaking, the actual amount that's paid at the start of the process is 5%, although the actual penalty which would be due if the purchaser later on decides not to go ahead with the purchase if all of the conditions have been fulfilled would be 10%. And assuming that the purchaser doesn't withdraw during the 10-day cooling off period, we then go on to the second stage of the process, which on our side is doing further information gathering, notifying third parties, and effectively getting into a position that we're ready to prepare the final purchase agreement. And on a purchaser's side, well, it's getting the money lined up effectively, whether that's from their own resources or whether it's from obtaining loan finance. And the second stage of the process, therefore, is once the various documents have been gathered and the funds are ready, then we would prepare the final purchase agreement, send purchasers a completion statement setting out the amount of the funds that we need to receive. And it's more often the case that people these days will sign a power of attorney electronically to authorize somebody in my office to sign the final agreement on their behalf. Before doing so, we'd have a meeting with them to, often a video conference, to talk through the agreement and make sure that they understand it and, respond to any questions. And then when that final purchase agreement's entered into, that's the equivalent of completion in the UK. So that's the stage at which the transfer of ownership of the property takes place, the transfer of the keys takes place, and obviously the rights and obligations relating to the ownership of the property.
Yeah. What's a typical timeline for that, Simon?
If it kind of depends on what conditions have to be fulfilled between exchange and completion. If we're talking about a cash purchaser, then generally speaking, it would be a couple of months. And if it's somebody who's looking to borrow, then it can be a bit longer. Often it's closer to 3 months.
Yeah.
So that's what I just described as the process. If it's a purchase of an existing property, if it were an off-plan purchase, then the names of the contracts are slightly different, and there's a lot more protections for purchasers up front, because in an off-plan purchase, then the building that you're looking to buy in doesn't exist yet, and so there need to be assurances that it will be built and that it will be built solidly. So that process starts off with the signature of an agreement which is called a reservation contract, which is an option to purchase given by the developer, subject to conditions being fulfilled again, which again can include the purchaser obtaining a loan. And on the developer side, it's going to be subject to effectively hitting the critical mass in terms of people signed up, so that they're in a position then to go ahead and enter into the final sale agreement. The conditions which have to be fulfilled on the developer side, which are imposed on them by French law, among other things, are, well, obviously owning the land, having planning permission, which is no longer capable of being challenged or withdrawn, and then having a form of financial guarantee in place by a third party, often bank, who stands behind the developer to ensure that the building works will be completed. And then there's various different insurance policies that they have to have in place as well. In terms of funds flow, again, with the reservation contract, well, generally speaking, it's 5% deposit, but it can be a lower amount if the project is at an earlier stage. And then when the final purchase agreement is entered into, it's an off-plan purchase agreement which will be signed, and the proportion of the purchase price payable will depend on what stage the building works have reached at that stage. So if it's just a hole in the ground still, and there's just going to be a fraction of the purchase price which is payable, generally it will be somewhere between 25 and 35%, depending on whether the foundations have been finished. And then there'll be milestone payments as the building works progress. So that's the main differences between the two systems for existing and off-plan purchases.
Just to go back in a couple of things or questions, Simon. Just to go back on the existing an off-plan property. Obviously, with the GFA certificate, that is based on the developer selling. Is it 50% of the sales price?
There's not a hard and fast rule as to how. Generally speaking, it's a percentage of units which are available for sale in the
Yeah,
development.
yeah.
And you're right that it's often 50%. There are some cases where it's higher, and there are some cases where it's lower, and it really depends on the individual bank who's providing the guarantee as to what level of people signed up that they require in order to grant the guarantee.
So when people say pay the 5% reservation, is that subject to the GFA certificate being approved, or will they do it
Absolutely.
before that? It's
No,
only
that's
subject.
Yeah, so that one of the conditions for the final purchase agreement to be entered into is that GFA will have been obtained, and therefore the 5% deposit, which is paid at the start of the process, that's effectively held in escrow and would be returned to the purchasers if the GFA isn't obtained within the timescale that's specified in the reservation contract.
So there's some buyers that might be in a case where they are buying early into an off-plan development, but they are protected by the GFA certificate being issued, but they won't have to pay any subsequent stage payments until that GFA certificate has been issued to the insurance that it's going to be built.
Correct. Yeah. So they would the only thing that they'll pay is the initial deposit, and
Yeah.
then the next time that a payment will be due is when all of the guarantees are in place, including the GFA certificate, and when the final purchase agreement is signed.
So the advantage is obviously from the off-plan point of view is that you can get into a development early, which might lend you to maybe better properties. But I guess the disadvantage is that you might be waiting a little bit of time for the sales to go through.
Effectively, I mean, with an existing property, then you generally know that you'll be getting it in a few months' time. Whereas an off-plan purchase, then it may be in a year or a couple of years, depending on what stage the development's reached.
Yeah. Just as an extra question, is there a way, if it felt like it was taking too long, does the 10-day cooling off period is obviously expired? Is there an option then for the buyer to say, I don't want to go through with this, or do they just lose their deposit?
No, in a reservation contract, there will always be a time period specified within which the final purchase agreement has to be entered into. So, if it's a 5% deposit, then the final agreement has to be entered into within a period of a year. And if it's a 2% deposit, it has to be entered into within a period of 2 years. And if the developer's unsure that they're going to be able to enter into it within 2 years, then they can't ask for any deposit. So if it's longer than a 2-year period, it's a zero deposit.
Yeah.
So if we're in a position where we're coming up to the end of the year and the developer hasn't been able to put in place all the necessary protections, including the GFA, then the purchaser at that stage can withdraw from the purchase and can recover the deposit.
Yeah, understood. Okay, let's just dip into one of the questions that was asked actually here, and then we'll go back to us because I quite like it. How are your notaire fees calculated on the prices?
Okay, I mean, again, it depends on. The first thing I'd say is that in France, notaire's fees, unlike the UK, are fixed by the French state. So it's not something that we have discretion over. Well, it depends on the type of transaction, but certainly in a property purchase transaction, it's fixed by the French state. The amount of the fees are fixed according to a tariff and effectively are pegged to the amount of the purchase price. And they're often grouped together with the other taxes which are due in the context of the purchase, like the equivalent to stamp duty and land registry fees. And so there's a kind of a common misnomer where they talk about notaire's fees, which in practice, are a small fraction of the overall cost which the purchaser has to pay. But they're fixed by the French state. They're pegged to the purchase price. To give a very rough idea, the notaire's fees for a pre-existing property, they're going to be around about 0.8% of the purchase price. And the total costs of purchase, including the stamp duty and the land registry fees, whilst it varies according to the overall purchase price, the rough rule of thumb is about 8%. And there's been a recent finance law which has been adopted in France, which allows each department to make a decision as to whether or not they're going to increase the amount of stamp duty by 0.5%. So, for 8% from in a month or two's time, read 8.5. And then from an off-plan purchase, it's a different level that we're talking about because there's a lower rate of stamp duty. But as a rough rule of thumb, the notaire's fees, stamp duty, and land registry fees on a purchase price are going to be in the range between 2 and 2.5%.
Yeah, that's kind of the rule of thumb. What other costs are involved in buying the property? Is there known, or is that pretty down the line?
The costs which are going to be due at the point of purchase, it depends. If somebody's borrowing, then there'll be a cost associated with documenting the loan and taking the bank security of the property. And that's a tariffed cost when a notaire's involved. So it's going to depend on the amount of the loan and the nature of the security. It's most common these days for agency commission to be borne by the seller, but in some cases it's borne by the purchasers, in which case that would be additional cost on top of the purchase price.
Yeah.
And then generally speaking, there are some small costs around the edges. For example, in an existing property purchase, then generally speaking, there will be a reimbursement by the purchaser to the seller of the pro rata of the property ownership tax for the period from the date of completion to the end of the year, and reimbursement of some of the kind of service charge and those type of things if they're being paid in advance by the seller.
Yeah, understood. That was actually the question that we had before, actually, Simon, but we seem to have kind of answered it, which is great. I just want to go back on one thing that I just when you're sorting out all the initial contact, doing the first contract, whether it's an off-plan property, what is the importance of the getting in contact with the mortgage broker, and at what time does that work? Because if you're obviously a mortgage and that first contract is fundamentally important, I assume the terms of that mortgage need to be put in that initial contract.
Absolutely. The loan condition, which would go into the preliminary sale contract or the reservation contract, it should include the details of the amount, the duration, and the interest rate that the purchaser is wishing to obtain. And effectively, in order to know what that's going to be, then come to find out what's potentially available and to be borrowed by the purchaser. So an early contact is welcome for with a mortgage broker.
Is there a situation where if they are not granted the mortgage, that it's written in the contract that they don't have to proceed with the purchase? That's okay.
Yeah, that's okay. I mean, generally speaking, the general principle under French law is that if a purchaser indicates that they need to borrow in order to pay part of the purchase price, that there will be a precondition for completion that the loan is obtained, and that's the condition which would set out the details of the loan that the purchaser wishes to obtain.
Yeah, understood. Okay, let's move on. We do have some questions, so I'll give it about another 6 minutes of us chatting, and then we'll go into some questions. One of the questions I have here is, what are the different ownership structures? I know you and I kind of spoke about this before, and actually recently SnowOnly have had quite a few people that are asking the same question. So what are the different ownership structures when buying a ski property?
At its most basic, then it's simply a purchase in the name of the purchaser without any form of vehicle in the middle. And for a lot of clients, they don't need anything more complicated than that. But depending on the particular circumstances of the client and the tax implications and so on, then the alternative is setting up a form of company to purchase the property. That, in principle, could be an overseas company or a French company. Generally speaking, buying using an overseas company is not recommended because there can be some adverse tax consequences of doing so, particularly on a resale. And so, generally speaking, both notaires and accountants in France will be advising setting up a French company. There are two broad types of French company. One is what's called a civil company, which is akin to a partnership, and which is transparent from a tax perspective. Those kind of companies are not really adapted to engaging in a furnished letting activity, because it leads to a requalification from a tax perspective of it makes those companies subject to corporation tax effectively, or the French equivalent. They're often used as simply as a property holding vehicle, so that you can have a number of family members as co-shareholders in a company that's just going to be used for the family. The alternative is a form of commercial company, and the one that one sees most commonly is something which is called an SARL, a SAL, and that's akin to a a UK limited company. So it's a limited liability vehicle. It is possible to make an option for that type of company to have fiscal transparency, which can, in some circumstances, can be interesting from a purchaser's perspective, as far as the treatment of the income tax and rental income is concerned, and also in a resale. Or it can be subject to the French corporation tax regime, which is called impôt sur les sociétés, which would attract a slightly different tax treatment. So those are the different types of vehicle. Now, what are the considerations in deciding what's right for each particular purchaser? I mean, it comes down to an analysis of each purchaser's circumstances, their family configuration, what they're planning to do with the property, whether their purchase is more of a purchase of a second home, or whether it's more of an investment. On an off-plan purchase, also whether they're looking to recover VAT on the purchase price. So it's difficult to give a kind of a generic advice on and say, well, this is the best answer. It really needs case by case analysis to work out what would be best for a particular purchaser.
Yeah, understand. So you have to take each case as it comes, essentially.
Yeah.
Okay. Are there any are there any restrictions on foreign ownership? There's not in France.
There's no well. There's generally speaking, no is the answer to that. I mean, there's apart from some exceptions, so there's no restriction on non-resident purchasing property in France. With the Ukraine Russian war, then there have been some restrictions recently on certain Russian nationals who have been put on a blacklist, but that's really an exception, a very extreme exception.
In regards to individual or a company, and if anyone is considering doing this, please reach out to Simon, because I'm sure there's going to be a lot more questions within that for people's personal circumstances in terms of children and family and death and all that kind of stuff, and how that kind of moves on. But just on a very basic level, Simon, is it easy to set up these companies, and does it take a prolonged period of time? And again, is this one of the reasons maybe to speak to you early before you purchase into the agreement, because these things might be a consideration?
I mean, it's the short answer to that is it is relatively straightforward to set up a company once you've decided what you want to do. It's not a very long process. I mean, it's not quite as quick as in the UK, where you can buy an off-shelf company that's already made, because it's going to be tailored to the individuals who are shareholders and the nature of the company. So generally speaking, you're looking at a couple of weeks really to get it set up once we've got the information. But it is a good idea to sort of start thinking about structuring relatively early on in the process, but it's not absolutely essential. I mean, in most cases, the preliminary sale agreement or reservation contract will contain a substitution clause, which will allow a purchaser to substitute in another person or entity to purchase at the final completion stage. So you don't necessarily need to have made the decision as to exactly the form of company and have set it up before the preliminary sale contract, but it's worth starting to think about it. And so that you can get things lined up, particularly if it's a purchaser who's borrowing, because in the end of the day, if it's a company that's going to be purchasing, then that application is going to need to be made to a bank, knowing that it's a company that will be the purchaser rather than an individual.
I think all these things, as obviously we spoke about before, I think all these things lead to the fact that it just reiterates how important it is to speak to you early, get all your ducks in order, so to speak, and then it gives you the ability to make a offer or a purchase moving forward on a particular property, knowing what you can and can't do.
Absolutely, and what I say is that we don't charge for providing individual upfront advice on with people who've got sort of questions about the purchase process and so on. So the sort of there's not a feed clock ticking to get in touch with us to answer questions. So from that perspective, I'd encourage an early contact, because it just allows us to allows clients to start thinking about the right things, and to to sort of like guide them in the right way early on in the process.
Simon, I think by saying that, you probably would have got a few more people emailing you over now with a ton of questions. Okay, we're kind of 30 minutes in at the moment, so let me just ask a few questions that people have asked us. One of them is quite interesting here. I think the lady, I won't mention the name, has kind of wrote it in the wrong order, but I'm sure you said that before. In terms of the searches from the notaire in terms of any on the property, especially if it's a resale property, in terms of defects on the house, how then afterwards can the price be? I guess the question is, what is the order? Because obviously, if you get the defects on the house, can the price be negotiated after they've seen that? But obviously, you've signed the initial contract, so kind of what order and what searches are involved?
Well, under the French system, the seller has an obligation to carry out various, I mean, the English term would be surveys. In France, they call them diagnostics. Now, they're not exactly the same as the types of surveys that were carried out in the UK, in the sense that they don't cover the structural elements of the property, but they do cover lots of internal things, depending on the age of the property and where it's located. And there's an obligation on the seller to provide those before the preliminary sale contract's entered into. So from that perspective, it's possible for in principle, that those should be provided to a purchaser before they've signed up. And therefore, if there's some horror revealed by them, well, either they've got the choice of not going ahead with the purchase, or potentially seeking to renegotiate the price to take into account whatever costs may be incurred in putting right any defects which are revealed. If there's something that's not revealed by one of those surveys, I mean, the general principle in France is that the property is sold in its current condition. So, what you see is what you get from a purchase perspective. So it is important for purchasers to do any due diligence that they want to do before they've signed the preliminary sale contract, or at least before the 10-day cooling off period has expired. Because after that, it's only if there's some form of hidden defect that it's possible to prove that the seller was aware of and had deliberately hidden, that there would be a possibility of for a purchaser to seek to walk away from the purchase, or if they were or risk losing the deposit effectively if it's something that happens before the final purchase agreement's entered into. And if it happened after the final purchase agreement's entered into, then effectively they're looking at a sort of damages action later on.
Yeah.
So reviewing the surveys early, and doing any other personal due diligence early is the best thing to do.
Yeah, just it kind of, you mentioned about the deposit. It just kind of led me to a question. I assume, but we'll say it anyway. But for resale properties, this might be a bit easier. But from an off-plan property, I assume all deposits are paid into an escrow, are they, rather than with the
So I mean, it's extremely rare for a deposit to be paid directly to a seller. In the majority of cases, they'll be lodged with the notaire in an escrow account open in the name of the purchaser. Occasionally, estate agents have their own escrow accounts, which are ring-fenced accounts, and they'll be lodged with the estate agent, which is in principle is just as secure. It's relatively rare, but it does happen as well.
Just a question here. It says, I heard there are laws around whether or not you can rent out a house depending on what band its energy-wise is. Do you know anything about that? Is this true?
Yes, that's true. In France, there's a draft of legislation which came in a few years ago and which has been modified recently. Like in the UK, there's an energy rating certificate which has to be produced by the seller and has to be provided to the purchaser, at the point of negotiation, effectively. The energy rating is banded A to G, G being the worst. from the 1st of January this year, there's a restriction on letting properties out which are in a G rating. The same will apply for properties in an F rating from 2028 and properties in an E rating from 2034. So it doesn't stop a purchaser using the property for their own purposes, but if they want to let the property out, then there will be these restrictions which will come into force, which is going to limit the possibility of renting, or if it's already rented, will lead to a cap in the rental income until the energy rating is improved. So there's also a requirement now. I mean, it depends. There's a difference between a property which is in an apartment block and a property which is a freestanding, house. But there's a requirement in certain circumstances where it's a freestanding property for the seller to provide something which is called an energy audit, which provides more detail for a purchaser about whether there's what works have to be done to improve the energy rating and what the potential cost is going to be if the property is in either an F or a G rating. So more information is being provided to purchasers.
Yeah. Simon, I think we've kind of covered most of the stuff. Otherwise, it's going to be very kind of specific information that we're going to provide. I think the main thing that we've kind of wanted to get from here, I think we've covered in terms of what your role is, the legal fees, the costs, the different ownership structures. I think obviously for anyone that's doing it, the time that you get in contact with Simon is definitely as early as possible before you've made the offer on the property, because it's important to understand how you can buy, etc., etc. Simon, is there anything you kind of like to leave us with in terms of any really good advice and golden nuggets of free information for these people?
That's a hard question. I think the best thing I could say is which you've just said yourself, Mark, is get in touch with us as early as possible in the process so that we can try and give guidance and try and avoid sort of potential pitfalls.
Yeah. And just to reiterate again, you work from anywhere from there's no kind of set budget. It's anywhere from any type of property that people are buying along the line, I assume.
Yeah, that's right.
Okay. Simon, I just want to say thank you very much. Could you share Simon's contact details? Chris, absolutely, no problem. We will do that for you. Simon, thank you so much for your time. I know your time is precious, and we really appreciate, and all the people on this call appreciate your time. We will give out Simon's details to everyone that has been on this call. You can get in touch with them, and as Simon pointed out, it is free until you start to engage him to buy the property. But hopefully everyone on this call is interested in buying a ski property. You can look for ski properties on SnowOnly.com, and obviously you can contact Simon at any point once we give you his details. So once again, Simon, thank you very much. Let me just finish off with a little bit of please leave a review if you've enjoyed this webinar. And I think the subject and having Simon's knowledge here is paramount to anyone buying. So if you did like this, please review us and leave a a review on Trustpilot. There we go. It's now on there. So you can click that. You can leave the review on Trustpilot. Thank you very much. Just to let you know, we also have a virtual event coming up in 3 weeks where you can make connections with trusted estate agents, property lawyers, visa experts, currency providers, and many more, and thousands of properties in your location. Thank you very much. Just popped up on your screen about the virtual overseas property show, which is Saturday, March the 22nd. Please all sign up. Again, free event just to meet people like myself and Simon and have a little bit of discussion on the things that you're trying to make your dream. So thank you very much for everyone attending. Simon, thanks again for your time. And I hope everyone enjoyed. Take care.
Okay, bye.